Okay.
Okay.
All right. So, without further ado, then, greetings to everyone. My name is Terence Corrigan. I'm a project manager at the Institute of Race Relations, and we are holding this this webinar, "The Land Question in South Africa: Opportunities and Challenges," in conjunction with our good friends at the University of the Free State. And Professor Solomon and I have been discussing these matters for some years. So this is what I hope will be the first of many such collaborations. South Africa, as we all know, has taken what has got to be the most severe battering in living memory over the past year. Someone said to me the other day that you'd have to go back to the Boer War to find something that it had a comparative effect on the country's economy. Unfortunately, this came as an addition to a great many other challenges confronting the country, and one of which has been the ongoing insecurity about land reform and property rights. This is an issue that I've certainly been writing about for some years, which we at the Institute have been talking about for well, probably going back to the 1920s in one way or another, but which is particularly hotted up over the period since 2017, when the African National Congress, in conjunction with the economic freedom fighters, decided that South Africa needed to move to a regime of expropriation without compensation. We hold this as South Africa stands just 7 days away from the end of commentary on the expropriation bill, another contentious piece of legislation that may advance this agenda. Now, in the next 2 hours, we're going to go through a journey of land policy. We're going to take a look at pending laws. We're going to visit some of the sadder corners of South Africa, the aftermath of the Bantustan policy, and we're going to hopefully take a glimpse into the future, looking both at the problems confronting South Africa, but also at perhaps what could be done to get the land reform agenda going in a way that encourages rather than detracts from the prosperous future that we all hope for. The land question in South Africa: challenges and prospects. I am going to call on our first speaker, Professor Philippe Burger, Pro Vice Chancellor and Deputy Dean of Economic and Management Societies at the University of the Free State, to give us a talk which he has called "The Forgotten: South Africa's Former Bantustans Today." So, Professor Burger, let me hand over to you.
Thank you very much. Can everyone see my slides? Am I on screen? Excellent. Good morning, ladies and gentlemen. So it's really a pleasure to be here today to talk about this issue, because it is an issue that is not really often getting all the attention it should. So I'm going to give you a bit of an overview of what the situation is, and then we can see from there onwards. So land reform in South Africa focuses on two issues. The first is the skew racial profile of commercial farm ownership, and then also the tenure rights on communal land under traditional leadership. Now, land redistribution and land restitution are supposed to deal with the skew ownership on commercial land, while tenure rights reform needs to deal with ownership on communal land. Now, I want to focus on tenure rights on communal land under traditional leadership and how such rights tie in to sustainable agriculture and the creation of livelihoods on such lands. Now, when we talk about communal land, we need to realize that we are basically talking about land that made up what was known as the homelands or the Bantustans in apartheid South Africa. Now, indeed, if you look at the map of where these communal lands are, and it's basically on this map, let me just put on my laser pen pointer here. if you look at that, so all these blue greenish areas, that's where the communal lands are, and you overlay that with a map of the old South Africa, the Bantustans, you will see it's virtually the same map. Now, when we talk about that, and we, just to give you an indication, so although I'm going to focus on land, to give you an indication of how bad economic and social conditions are on this land, if you overlay this map with a map that I got from Passmark showing where pit toilets in schools are, you can see it's virtually the same map. And again, let me just show you. So, I mean, you can see how the map of pit toilets at schools basically trace out the map of the old homelands. There's the Transkei, there's the Ciskei, there is Bophuthatswana. If you compare that piece of land there it is. There's the old Venda. There's Tabanshu in the Free State. So that is basically what we have. Okay, so what few people realize is that up to 32% of South Africa's population in the 2011 census still live on traditional land. And now South Africans migrate or urbanize at about a rate of 0.5 percentage point per year. So over 10 years, because that was 2011, we are now in 2021, that might be around about 27% at the moment. So that is still almost, 30%. That's still a very high proportion of South Africa's population that still find themselves on traditional land. If we go into a bit more detail, we'll see that according to the 2011 census, 16.5 million people lived on traditional land. At the moment, that's roughly about 18 million. Now, 9.5 million of those were of working age, of which only 1.8 million actually were employed for a wage or a salary. There were another about 1.8 million who were subsistence farmers, with an overlap of a few between those who are employed for money and those who are subsistence farmers, which meant that in the end about 3.1 million people were either working for themselves or in the form of subsistence agriculture. Compare that to the 9.5 million of working age, and you can still see that it's less than 30%. There were also 4.6 million people whose daily activities comprised fetching water and wood. So it is really dire economic conditions. Now, we know that in South Africa, the official unemployment rate in pre-COVID, just pre-COVID, in the first quarter of 2020, was about 30%, while the broad unemployment was about 40%. Now, the broad unemployment rate includes all those who wish to work but have given up looking for work because they could not get a work. These are the discouraged work seekers, and half of those people also find themselves on communal land. So, living conditions of formal homelands are really dire and much worse than in the cities. So we can say that in South Africa, in reality is not two nations as Thabo Mbeki defined it, but three. There are the rich and the poor in the cities, and then there are the even more poor or the even poorer on deep rural areas, or what basically were the former homelands. So when we speak about deep rural areas in South Africa, basically what we talk about are the former homelands. So that is what we look at. So what is the problem? Now, I want to argue that to a large extent, the poverty we see in communal areas can be linked to the lack of tenure rights. People live on land, work on land, but do not have tenure security. Thus, they cannot use their tenure rights to leverage themselves economically to a better financial position. Now, according to Article 25(6) of the Constitution, they should by now have had that tenure right, because that article clearly says a person or community whose tenure of land is legally insecure as a result of past racially discriminatory laws or practices is entitled, to the extent provided by an act of parliament, either to tenure, which is legally secure, or to comparable redress. Now, according to Article 25(9), that article then reiterates the need for government to implement Article 25(6). Now, presumably, all articles of the Constitution must be implemented. So dedicating a specific subsection of an article to emphasize that another subsection of the same article must be implemented points to the urgency with which the Constitution's authors considered this matter. Unfortunately, the legislation required by Article 25(6) has been disappointing. There is the so-called stopgap measure called the Interim Protection of Informal Land Rights Act of 1996. But note that this is interim for 25 years now. It was just extended again for another year on the 11th of December in 2020. So, there's no indication that things will change anytime soon. Thus, a quarter of a century after the Constitution states that people should get secure tenure rights, they still do not have such rights. In fact, the government created legislation that sought to strengthen the power of the chiefs and not secure the tenure rights of people living on communal land. The two most notable acts were the Traditional Leadership and Governance Framework Act of 2003 and the Communal Land Rights Act of 2004. The latter act specified that chiefs represent the interests of their communities and can decide what is in the interest of their communities without communities having much of a say. Of course, it was struck down by the Constitutional Court in 2010. But things are not getting better with two further pieces of legislation, one of which Parliament approved and the President signed into law, and the other is still before Parliament. So the first is the Traditional Khoisan Leadership Act of 2019, which replaces the Traditional Leadership and Governance Framework Act, and which commenced on the 11th of December 2020. The other is the Communal Land Tenure Bill, which is still a bill at the moment, of 2017, which is supposed to replace the Communal Land Rights Act. But these bills are not improvements on their predecessors. They still leave tenure rights not secured in the hands of people living on land, and control will remain with the chiefs. This is still at odds with the Constitution. And on top of that, you have other pieces of legislation that seek to strengthen the hands of traditional leaders and chiefs, such as the Traditional Courts Bill, passed by National Assembly, then passed and amended by the National Chamber of Provinces, and returned to National Assembly for concurrence on the 2nd of December 2020. So we can expect it, I guess, somewhere this year to be finalized. And then there's the Restitution of Land Rights Amendment Act of 2014, which was declared unconstitutional in 2016 because of the big backlog of past land claims that were still not finalized. And then you had this bill or act that just extended and opened it all up again. Now, all of these acts empower traditional leadership at the expense of the people living on the land. And you can see that in the large numbers of cases people living on the land bring against these chiefs. Now, in Chapter 12 of the Constitution, it says that there should be a role for traditional leaders, particularly on local level. But note that the Constitution talks about a role. It does not say that they should have power. So more than a quarter of a century after the first democratic election, there is still no tenure security for almost 1/3 of the South African population living on traditional land. So that brings me to the question. In essence, the literature on land reform tells us that there are a number of possibilities how we can deal with these. Now, I want to discuss two of the three I've listed there. I can, maybe if there's question time afterwards, we can talk about the third. But the first one is individual titling on land, and the second is communal land combined with small-scale farming. So, in terms of individual titling, Hernando de Soto in his 2000 book Mystery of Capital famously argued that the problem in developing countries is not that they have too little capital, but that ownership of capital is not properly titled. Individuals might farm on pieces of communal land allocated to them on their and on which they live, and they and their families work there, but they do not have individual title deeds to this land. It is impossible for people to sell this land or to use it as collateral to obtain investment loans. So De Soto's proposal entails the allocation of title deeds to individuals, thereby allowing them to use the land as capital to improve their lives. However, I want to argue that pure title deeds are not the solution. Penny Lee in 2006 explored the case of Aboriginal land in the Northern Territory of Australia and find that the remoteness and small size of communities, as well as the harsh climate conditions, make it highly unlikely that individual titling will be financially viable. In South Africa, the problem is that on communal land, some individuals harvest maize. And then when the harvest is off, someone else's cows graze there. And people from various families collect food, water, wood on the same piece of land. And then various families live on this piece of land. There are therefore overlapping use rights to land. And property rights, on the other hand, are exclusive, meaning that overlapping use of land will be stopped. Now, given the power structure on traditional land, with power usually vested in males, the real risk exists that establishing exclusive property rights will disempower women and even cause their levels of poverty to worsen. So what other options exist? Well, I think for that we need to think a bit outside the box. And there is a way to think about this. The first is to look at a two-tier or two-level rights of tenure rights, so to speak. On the one level, we can say, okay, keep the land communal. But on a different level, we recognize the overlapping secondary use rights that are currently in place and do so in law. Then we can democratize the control over communal land, taking power from the chiefs and putting it in the hands of the communities. This takes control away from the chiefs, but does not deny them their constitutional right to have a role in society. Note again, a role does not imply power. A role can be limited to aspects of tradition, to beliefs and culture, while control of the land then resides with the people living on the land. Securing use rights in law means that someone operating a piece of land to grow maize or raise cattle will be in a similar position to someone leasing land. So you don't own the land, but you own the income stream coming from that land, and you can pledge that as collateral to get finance to empower your farm. That can allow you to create what I would call a livelihood plus approach. In other words, you're not just making a livelihood on the land, but you're adding a bit. But this, unfortunately, is not sufficient. We need more. We very often think that once land has been redistributed or restituted, that all will be fine. But the dismal failure of many farmers on restituted land or land under control of community property associations show that just dealing with legal aspects is not enough. What is also needed, or even more needed, is the design of an economic ecosystem within which small-scale farmers operate. Remember that many, if not most, of the communal land areas are very remote and far from markets. And this led to bizarre situations where, for instance, 47% of the country's cattle are on communal land, but only 5% of cattle in the market come from communal land. So what we need is the reconciliation of economics, in other words, the need to run a sustainable farm and ensure food security, with the need to ensure cultural and communal links to the land. This is not an easy pursuit and requires some out-of-the-box thinking. Economically, what is needed is the creation of supply chains that look at both the upstream and downstream elements of farming. Upstream, we are talking about input costs, the cost of seed, fertilizer, and water. And capital. Capital is very expensive. And we know from data, national accounts data, that the capital output ratio in agriculture is, after that of the utility sector, is the highest in the land. So agriculture is in fact more capital intensive than even manufacturing. Just think of all the tractors, fencing, storage, and so on that you have. Again, there is a bit of a business opportunity here, because if you are an entrepreneur, you can basically buy a tractor and rented out to all sorts of small farms. That brings me to the downstream, and I'm almost done. Downstream, we're talking about one-channel marketing. So Woolworths, for instance, would prefer not to buy from 200 small farmers, but from one big supplier. So here again, there's an opportunity to band together and have farmer-owned co-ops who can do this one-channel marketing. And then there's, of course, lastly, just the need for extension services and training for farmers, where the government, the private sector, and universities can play a role. So I want to conclude to say that the policy debates in South Africa very often focus on the formal urban economy. But almost a third of our population live on traditional land, on communal land, and half of all discouraged work seekers find themselves on such land, while poverty levels are very, very high. So I think that there is really a call here to look at the development of traditional land in an agricultural sense, and as a foundation for that, we do need a proper system of tenure rights that empower the people on the land. But that will take some tough political decisions in coming years. Thank you very much.
Thank you very much, Professor Berger. That was fascinating, and I heard in your presentation many of the arguments that are being had around the world. How does one incorporate the let's say the peripheral or the traditional economy into a modern economy, so that it actually provides a means out of poverty and an engine for development, as opposed to simply becoming a trap for generational poverty. Moving, and I think also what I would like to compliment you on here, the erstwhile homelands were often referred to as the dumping grounds, or as the place where people were disposed of and went to be forgotten. And it's I think a shame and a scandal of post-apartheid South Africa that all too often in reality this remains the case. So moving on, up next we have Dr. Ina Gous, Senior Lecturer in the Department of Political Studies and Governance at UFS, stuck in the smudge of implementing land reform policy. And I think anybody who has delved into the morass that is our land reform policy would probably appreciate the choice of the choice of language there. So, Dr. Gous, I would like to hand over to you.
Good morning, everybody. Yes, it's my task to talk about something that we are talking about every day, I suppose. The smudge is an interesting verb, and even a more interesting noun, I found. It's a verb that means to cause something to be or become messily smeared. And as a noun, it refers to a blurred or smeared mark on the surface of something. A grim outlook, to be sure. The management of policy implementation in South Africa has been marked by an administration causing a messily smeared landscape, where very little progress has been made toward growth or development.
Okay, hierdie gaan interessant wees.
If I could just ask everybody apart from the speaker to please mute your microphones. Thank you.
Let me repeat then that part. The management of policy implementation in South Africa has been marked by an administration causing a messily smeared landscape where very little progress has been made towards growth or development. This smudge therefore also exists where land reform is to be planned for, developed, implemented, and monitored. Let me first, for what it's worth, reiterate that land reform is of course necessary and when implemented effectively has the potential to contribute greatly to our growth and development. Colleagues will get to the aspects pertaining to legislation later on. What I'm attempting here for the purpose of our discussion is maybe a reminder of sorts of what successful implementation requires. Just think again of the path this policy has taken thus far. The ruling party adopted the expropriation without compensation as a policy after the failures of willing buyer and willing seller. Failures, I might add, almost entirely due to bureaucratic failures and corruption. And yes, the unwillingness of sellers to sell. We now have the bill before us for public comments, and hereafter follows the lengthy parliamentary process. Once adopted by Parliament and signed by the President, it's law. What is not talked about enough, I believe, in circles outside maybe the law circles, is the subordinate legislation that may have to flow from this on provincial level, as regulations, proclamations and such, and bylaws on local government level. And I say may have to. And how this might impact on the implementation requirements and the processes on the ground. We have ample evidence of government failures where implementation is concerned. None more so than in the very early stages of policy making and writing of laws. Do we, for instance, have the resources needed in place to succeed? Common sense, one might think, but a serious admission when politics is more important than the actual outcome. In our country, it seems the main challenge is that of entrenched vested interests in both commercial and communal land spaces, and the main constraint is the poor capacity of organs of state to deliver these mandates to begin with. The acquisition of land, of the for its distribution, the definition and qualification of the beneficiaries, the land rights and tenure in various contexts for citizens and non-citizens, land settlements and production models, and then the state support to productive land. And we have just listened to all the other aspects that must be considered from Professor Berger. The policy sector forms part of, as we know, the macro structure. And we remember Berman telling us back in the day that this sector is typically characterized by, tacit operating rules of the game, established roles, routinized procedures, and reasonable, stable conditions. Now we are having, evidently, increasingly less stable conditions. Furthermore, the policy sector is also a myriad of activities where the different sectors, such as education, health, and housing sector, interact in somewhat unsolidified, habitually frenzied and conflictual manners, to quote him again. And this adds to that macro implementation, also risks, for instance, the aspects of goal discrepancies. There's influence and authority differences. There's a lack of resources and communication problems among public implementation actors, policy implementation actors, such as different organizations and, of course, the different departments. We sit with a political administrative system. It gives rise to a high organizational complexities, which may increase bureaucracy that may occur due to a high increase in the number of public officials, and the levels of government which have to be assigned with the task of implementing these policies. Furthermore, there is the possibility that in interpreting the policy aims, both by the principal policy makers and agents for implementation, it can create an environment where there is a deviation from the original course of action concerning the policy guidelines, especially when it takes too long to see the real impact or results. I fear our administration is not able to adapt to such situations very well. It is so that policy execution is a major issue in many underdeveloped and developing countries like South Africa. This is as a result of the lack of financial resources or the lack of human capital, the defective management processes, and organizational cultures which are more inclined to obstruct rather than promote successful public policy implementation for whatever reasons. And indeed, we are checking most of these boxes. It will be no different if these issues are not addressed when it comes to land reform policy implementation. However, there is, of course, that one discrepancy that some public policies tend to share in the realm of South Africa's public environment, and that is the failure of a number of policies, public policies, to produce the intended result as clearly stipulated in the policy document. It can therefore further be stated that this becomes a major headache, as most public policies fail to materialize in the way they have been intended to. And often these public policies have been aimed towards improving the lives of the disenfranchised members of South Africa. So the failures of these policies that we have seen, particularly when it comes to poverty alleviation, has created a sense of skepticism among South Africans to begin with. And that has a real impact of unsuccessful policy implementation. When these policies do not answer to the call for public opinion, also the general public often takes to the street to convey their dissatisfaction with government, which we have seen more and more, and not just in protest, but in ways to alleviate poverty, in the sense where looting and stealing and such more criminal activity has become acceptable to a population who sees no other way. When implementation of these then do not answer to the call of, as I said, that the general public take to the streets, frequently this type of participatory action is then in the form of what we have seen in protest. We talk about specifically goal discrepancies as well, that just stand still for a moment at the issue, for instance, of property ownership and tenure. It is clear that there's already conflicting views on this between government factions in the ruling party, the various opposition parties, civil society organizations, and sectoral organizations in agriculture, etc. It is feared that we may very well see land reform being implemented from court benches if these conflicting views are not sincerely addressed in the appropriate ways. Another point to raise is the integrated nature of policy implementation and recognizing that all must be involved, and recognizing all that must be involved in agricultural land reform alone. For instance, state investment in appropriating technology, agricultural research, social services in rural areas, infrastructure, education and training, extension services, cheaper credit, transport, water. All of these aspects needs to be kept in mind. Land reform farmers also require access to quality land, the necessary management and entrepreneurial skills, and agricultural equipment that supplies such as seeds, fertilizer, fencing materials, and insecticides. And in addition to state support, land reformers are also more likely to succeed in a politically stable environment where favorable economic conditions prevail, such as good prices for agricultural produce and well-functioning and accessible markets. When we look at these things alone, various questions can be asked, various red flags are lit up. And I doubt that in the first place, the policy as it stands will address these things properly. And as far as addressing these issues in the implementation process, I don't think our administration has the capacity or the know-how to do this. So ultimately, we can't get away from these facts. Our administration lacks administrative capacity, insufficient resources, and is guilty of policy ambiguity. Policies describing the what without the how will perpetuate this, and I fear we are back with this problem. Social acceptance when it comes to compliance and consensus is diminishing because of lack of trust. Lack of trust, South Africans come by honestly because of the government's questionable record of implementation, especially pertaining to basic service delivery. Policies are at times overly optimistic, and already skeptic population is no longer buying into attempts by a government that lost credibility. You have to have the cooperation of actors and everyone involved in the public process. And that public opinion should be taken into consideration, and that government should listen to the legitimate grievances of the citizens in order to avoid pitfalls. And this includes experts, organizations who have capacity, know-how, to be able to contribute to these issues. You know, a main premise of public policy is that it should be in harmony with the public interest. So our interests may be the same, which is to live decent lives, but inequality makes the divide quite big in how we are going to get there. We need a government who understands this and is able to address it. Furthermore, what the South African government must realize is that in order for participatory democracy to be positive, concrete feature in South Africa's political climate, it does not do justice to have public policies written but not adequately implemented, thus yielding this negative side of participatory democracy. So what do we do? And this is my last thought. As a much more active and informed citizenry is required under the current circumstances. This participation cannot only be in the street and protest, but right now, when a bill is before us for comment, a movement can be ignited. When it comes to implementation, we must be vigilant and vocal against attempts for corruption. We will need to become part of social structures outside government that understand the need for reform, but insists on lawful, practical and growth-oriented implementation. We've seen this taking control, this type of taking control starting to occur in various municipalities, which seems to be very inclusive groups of people taking charge of service delivery, until there is once again an effective, responsive and accountable administration in place. My question is, what choice do we have but to take this course of action? We must move through the smudge then, or clean it up. Thank you.
Thank you very much, Dr. Goos. Very, very interesting and very enlightening. I must say that I'm probably dating myself here a bit, but I was a student in the early 1990s. And an anecdote I always share whenever I speak to one of my former lecturers or professors is to say, remember those rip-roaring discussions we had about the role of the state? How big, how small? Did we ever actually stop to ask how capable? And there's a sort of wry acknowledgement. So you know what I take away from what we've just heard is we have a systemic problem, starting with the inappropriate conceptualization of policies, through a lack of focus, through poor implementation, and a system that is not capable, that is not, to all intents and purposes, often not capable of delivering. And where then does it leave those of us who are concerned about South Africa's future as an open, democratic, and hopefully one day prosperous society? This is a responsibility that therefore falls on all of our shoulders. Moving on, I have great pleasure in introducing Dr. Anthea Jeffrey. She is my colleague, and I wonder if she remembers this. She was actually my boss briefly in 1997. Dr. Jeffrey is a prolific author, and I would say one of South Africa's sharpest legal commentators, and has devoted a great deal of her life to examining questions around property rights, and is, I would say, probably South Africa's leading authority on the pending expropriation bill. So without further ado, then I'd like to hand over to Anthea, and we look forward to her analysis.
Thank you very much, Terence. I hope everybody can hear and can see the presentation. If I don't hear objections, I'm going to proceed on that basis.
I don't see the presentation.
You don't see the presentation. Sorry, can I call for my technical team to advise and help with this? Sorry.
I'm afraid many of us who missed the tech generation suffer from this malady. I know that I certainly do.
Sorry, I seem to be just having a general difficulty. Maybe I must simply go through without having the presentation because I can't see how to get it up. Zoom is
Anthea,
and technical support's not around.
Hi, Anthea. It's Herman here. I was just wondering. I could try to talk you through it from the team's perspective, if that might help.
Thank you very much. With apologies to everybody for technical problems.
No, I think everyone has understanding. So the first thing is you should open the PowerPoint file as on your computer, so that it is, open in its own window. And then once you have that up in the background, return to the Teams program.
Okay, so I've got that. Then I return to the. Now I need to minimize that, I presume. Then I return to the Teams program.
Yes, and then there should be at the top right-hand side of your screen, there should be a little block with an arrow pointing into it. Yes. So then you click on that. Something's happening. There we go.
Yes, this time we see
your
Thank
presentation.
you. I thought I had it all in the right place and then it disappeared. So thank you very much, Herman. Right, so rather later than anticipated, let me start with apologies and thank you for your patience. So I'm going to be talking about the expropriation bill and in particular the nil compensation clause and various other difficult provisions in it that are likely to cause problems. So where we're talking about nil compensation under clause 12.3 of the bill, this is a situation where the state plans to take ownership. In other words, it's envisaging a direct expropriation as opposed to an indirect expropriation, which I'll talk about in a little while. And the clause refers to land only, but that does of course raise the question, what about if improvements that accede to land? That of course would include buildings on the land. It would include everything from shopping centres to houses and also things like mine shafts. Will they effectively be included because they accede to the land? The bill lists 5 circumstances where compensation may be nil, but the list of course is open-ended. The relevant instances include, but are not limited to, the ones that the clause then goes on to set out. So if you look at the list, it says that nil compensation may be just and equitable. First of all, where A, land is unused and is being held by its owner in the hope of a rise in market value. Secondly, where land is being held by an organ of state, which doesn't actually need it, which got it for free, and which consents to the expropriation. C, where land where the owner has abandoned it by failing to exercise control over it, despite still having title. And that's really one of the most controversial tests because it's not clear what not exercising control means. And one can take the example of people in KwaZulu-Natal, the Imnyandus, who were forcibly evicted from their houses on a former Lutheran mission. This was supposedly done by an impi under the control of the local traditional leader. The police were present, but they did nothing to help. They simply stood by while the houses were burnt and the Imnyandus were driven off. Subsequently, they were threatened with death if they tried to come back, so they were not exercising control over their land. Does this mean that they should now have it expropriated from them for nil compensation? Or what of the owner of a hijacked building in Johannesburg who can't afford to bring an eviction case and so also has no control over his property? Fourth one is land with a market value equal to or less than, and here I've written it all out, the present value of direct state investment or subsidy in the acquisition and beneficial capital improvement of the land. And I think the word "and," which I've italicized, is significant. So this would probably apply where the state has helped a farmer, for example, to buy and improve his farm. But let's think of another example. What about a factory on the East Rand? The land has been improved by the infrastructure created in the area through state investment in roads and electricity pylons and a nearby airport and so on. Is that enough? Probably not. But what if a manufacturing grant had also helped the factory to buy the land? Would it then also qualify for nil compensation? And then 5, we have the nature or condition of the property, this time not a reference to land, but rather property, which is wider, that poses a health, safety, or physical risk to others. And again, one can imagine some of the inner city buildings in Johannesburg where fire dangers exist. Does this mean that the owners of those lands must see them go to the city metro for no compensation? In addition, effectively a 6th category, nil compensation may be just and equitable where a court or an arbitrator is deciding on compensation under the Land Reform Labour Tenants Act of 1966, but that of course has quite a small application, only where a labour tenant working on the farm for many years on a particular piece of land has the right to claim ownership of that land, and the question is how much compensation the farmer should receive.
Anthea, is it possible for you to move your slides up a little? They all seem to be stuck on the first one.
I think, Anthea, that there might be 2 PowerPoint options that you could be sharing. The one might be the actual presentation and the other one in the document form.
Right. I'm afraid, again, I don't know what to do there.
All right. What I suggest is perhaps stop sharing the current screen, and then we can try getting the other one up on where it needs to be.
Okay.
Apologies.
So this I need to just close. Let me just see whether I can find a place where I can stop sharing. There's normally a little control, and I don't see where it's gone to.
The screen has moved on now, so it is right. So maybe one can just keep rotating up and down.
So then what do? I minimize this on my screen. I still have the and then I'll go back to Microsoft Teams if I can. That seems to.
Yes, we can still hear you, so that connection is at least still up and running.
No, but I think I've got the wrong connection now.
Right. You need some tech support.
I do need tech support. It's the thing I hope to find on the screen disappeared when I tried to share it. So it should be somewhere down there.
So you are currently presenting?
Yeah, so I should stop presenting because they weren't able to see the whole screen, the whole thingy.
Okay.
And then if we go back to the beginning, from the beginning.
So guys, can you see that?
Can you see this?
Yes.
And can you see me moving through the screens?
Yes.
No, we're looking at the PowerPoint not in its presentation mode, but as if it's an open document.
Yeah, maybe just click at the bottom there on slideshow.
No, it's strange because on our side it actually is in slideshow.
There's an option with Microsoft Teams to either share a specific open window on your desktop or the entire screen. Perhaps select the option of sharing the entire screen.
All right, so let's try screen sharing. And into slideshow. Is that giving you a full screen presentation now?
Yes.
Yes, there we go.
Okay, and is it moving through?
It is.
Okay, perfect.
Well, I think I am going to rather rush the first bit in the hope that people will be able to remember what I said and have a quick look at the slides.
Yeah, just pick up from where you were. I'm sure.
Yeah, people
I'm sure
are
there's no problem.
familiar enough. Yeah. So we talked about the Imanyandus, the possibility of a factory being in difficulty on nil compensation, and then the labour tenant issue. I was making the point that much of the wording in this clause is so uncertain that it would be void for vagueness, according to tests laid down by the Constitutional Court. There are also other questions. Why should an organ of state be spared unless it consents to an expropriation, whereas other owners, of course, are treated differently? And a critical point, though the clause says that the courts will be deciding on nil compensation, they may never get the chance to decide, particularly if the expropriation takes place very quickly and the owner can't afford litigation. And that moves us on to the kind of procedures that the bill envisages and how much they benefit the state. So an expropriating authority, such as a municipality, has to start with a number of rather simple preliminary steps: negotiation, investigation of the property, the issuing of a notice of intention to expropriate. The owner's representations have to be considered, but they need not be answered. And once the municipality has gone through these steps, then it can serve a notice of expropriation on the owner. And this will state the date of expropriation, which is the date on which ownership will automatically pass to the municipality by operation of law. And from that moment on, the municipality is entitled to the title deed. The owner's ownership rights entirely end. This date could be set for a day or a week or a fortnight after the service of the notice. The only limit that is stated in the bill is that the date of expropriation cannot be prior to the service of the notice. The right to possess the property will also pass to the municipality on a stated date, so there'll be a second stated date. And this also has no time limit. And again, it could be set for very soon, perhaps a week after the ownership right has passed to the municipality. And an owner who may now already have lost both ownership and the right to possess the property, but who wants to challenge either the validity of the expropriation, is it really in the public interest, or the amount of compensation, he will bear the onus of proof. And the practical consequence is that he will have to pay his own costs, plus much of the municipality's costs, if he fails to convince the court. And that, of course, is a very daunting prospect, particularly for people who may be poorly resourced and whose lives have in any event been turned upside down by the sudden loss of their property. And the procedures are unconstitutional. The municipality must bear the onus of proof and must have to show that the expropriation complies with Section 25, of course, the property clause, plus other relevant sections, which would include Section 9, the equality clause, Section 26, the prohibition on eviction from your home without a court order, Section 33, which deals with just administrative action. And the municipality must obtain that court order confirming that there's compliance with all relevant sections, before it proceeds with the expropriation. But the bill as written allows the state to treat expropriated owners worse than criminals. If you have a warehouse which is used for storing heroin, for example, it cannot be seized by the state without a prior court order in the form of a search and seizure warrant. And the bill, in fact, does require a court order in some situations. For example, before a municipality can enter onto property that it wants to investigate with a view to its expropriation, before entering the property, it needs a court order. But the bill nevertheless allows the municipality to implement its expropriation without a prior court order, and that is an absurd inconsistency. The bill will effectively allow the expropriating authority to act as judge and jury in its own cause. Its real motive might be to replenish its coffers, but if it claims that expropriation is in the public interest and that the compensation is just and equitable, it's then able to act on its own say-so. The definition of expropriation in the bill is also problematic. It's defined as meaning compulsory acquisition by an expropriating authority, and that might look fair enough. But it's based on Chief Justice Mogoeng's ruling in the Agri-SA case in 2013, where the state acquired custodianship of an unused coal mining right that had been bought by a company for R1 million and then was lost by the company because it couldn't afford to apply for it to be converted into a new order mining right. So when the state acquired custodianship of it, the company no longer had what it had paid R1 million for. Was compensation on expropriation due? And the Pretoria High Court said yes, but the Constitutional Court said no. And Mogoeng's approach was this: whatever custodian might mean, it does not mean that the state has acquired and thus become the owner of the rights concerned. The state's assumption of custodianship over the unused mining right was therefore not an expropriation, and it followed that no compensation was payable because the deprivation is not enough. It's not enough to show that the state has deprived you of your property. There also has to be an expropriation for compensation to be due. That has major implications for custodial takings. A custodial taking, it seems, will not qualify as an expropriation, as there will be no compulsory acquisition by the expropriating authority. If you recall, Mark Mogoeng said the assumption of custodianship is not enough. And the ANC, as we know, would like to take custodianship of all land. It planned to do so for all agricultural land under the Preservation and Development of Agricultural Land Bill in 2014. It mooted doing exactly that in the report on the land audit in 2017. A senior land official speaking at Davos last year made it clear that custodianship was the ANC's preferred option. And the EFF has spelled out the implications. Title deeds will mean nothing, and everybody will need land use licenses and will presumably have to pay land taxes and rents. The legal position, I must say, is not entirely clear. Mogoeng was dealing only with an unused mining right. It's arguable that what he said in that case can't be extrapolated into other situations. It's arguable that there was no general principle laid down, but there's also some doubt about that. 3 judges did criticize him. So there's a possibility that his judgment could be distinguished and then not followed, but clear the intention of the bill is to make it possible for custodial takings to proceed with nil compensation. And if we look at the impact on land reform and property rights very broadly, there may be a speeding up of land transfers to the state, of course, not to beneficiaries. That won't help the land reform beneficiaries who would like to have ownership for themselves, but there will be no title for them. And the key problems bedeviling land reform, which we've been hearing about this morning, will remain unresolved. As the high-level panel put it, for example, there's a high level of inefficiency, there's elite capture, and critically, that emergent farmers are not giving title and so cannot easily raise working capital. But it's not only land that's an issue. Property, according to the bill, is not limited to land. So assets of all kinds are at risk, including the SAIRR shares that the EFF would like to see nationalised, pension savings that the government would like to access, and patent rights which it's been angling to acquire for many years. And the bill is just as unconstitutional as the current Expropriation Act of 1975, which is rather an irony. We're told we have to replace that act because it's inconsistent with the Constitution, and we fix the two relatively minor inconsistencies. But the bill ignores the very big issue, which is that we now have a constitution. If perhaps a municipality in 1975 could take property simply by issuing a notice of expropriation, but now we have a constitution and we have many constitutional requirements, and that simple solution for the municipality is no longer applicable. Instead, one must recognize that the bill is inconsistent with Section 1, which deals with the supremacy of the rule of law, Section 25, the Property Rights Clause with its expropriation requirements, 26(3), which says nobody can be evicted from their home without a prior court order, and a farm, for example, might include a farmhouse. Section 33 says everybody is entitled to just administrative action, which is fair and reasonable. And Section 34, access to court, the right to have disputes resolved by the judiciary, not unilaterally decided by entities of state. And the big risk, particularly at this in the middle of COVID state, is that we're going to stall economic recovery, that we'll risk debt default, that the government might resort to the printing of money, that this will trigger hyperinflation of the kind that we've seen in Zimbabwe and Venezuela, and the prospects of prosperity that are so important for all South Africans will be even further removed. Thank you.
Thank you, Anthea. As always, in my experience with you, comprehensive and well argued. I'm going to skip directly onto my presentation, where I will be discussing what I describe as implications upon implications. What, in particular, my interest here is what are the implications of getting land reform wrong. This is
Terence.
Yes.
I apologize to quickly cut in. Anthea, you see on your screen the red leave button. Just to the left of it is a little block with a cross. You can click on that one. Excellent, thank you, Terence. It was just to get Anthea's privacy back to where it should be.
Okay. I trust everyone can see what is on the screen. We did have some issues with some of the graphics when I did a little dry run earlier this morning, but I think it should be adequate for the purposes at hand. My interest here is what are the implications of all this? If we get land reform right, what does that mean? If we get it wrong, what does that mean? Now, I recall my first engagement with land and land reform issues was with the expropriation bill, I think in about 2008, 2009. And I did some reading up about this, and this was a quote that came from two economists at the World Bank. Although redistributive policies have the potential to benefit poor both directly and indirectly, they will only do so if redistribution does not jeopardize investment. This may be the one explanation for the observation in the past redistribution policies such as land reform have often failed to help the poor. That brings me to what I would consider my, let's say, land reform model. You have to balance the redistribution function, giving assets to those who have been deprived them or who lack them, enabling them to use those and create a basis for saving and investment. That is the model of Japan, Taiwan, and South Korea. Improperly executed, though, you can undermine valuable productive operations without replacing them, and more than that, you can inflict great damage on the wider society. Its investment prospects, and also its institutional and political environment. This is what happened in China in the 1950s. This is the story of Venezuela, and this is the story of Zimbabwe. Now, frequently when I've heard officials talking about this, so we're not going to go the Venezuelan route. We're going to go the South Korean route. Well, the question is, are you doing South Korean things, or are you doing Venezuelan things? South Africa's challenges. I've got three quick slides. The first one shows economic growth in emerging markets in 2005 and 2022. The blue line is an aggregate of the growth rates of a basket, these countries like Indonesia, the Philippines, Mexico, Estonia. The brown line underneath is South Africa. Now you'll notice South Africa since around 2005 has tracked at about half the rate of its comparator countries. This is not a good situation. Remember, this is also takes into account things like the commodities boom. This isn't all Zuma and state capture. There is something wrong with our structural conditions. Now, this is unfortunately, it seems, where my my graphics are letting me down. Gross domestic, gross fixed capital formation, that's investment as a proportion of GDP, 2000 to 2018. What you should be seeing on this is that it reached a sort of high point, hovering in the low 20s. We have never reached the 30% mark for investment. In other words, putting money into creating things that will have a multiplier effect. That's what the National Development Plan speaks of 30%. We're nowhere near there. We need to create the environment that that brings that in. And the other one is unemployment, and what you should be seeing there is, frankly, a horror story. You're talking about an official unemployment rate that is one of the world's highest, at least for countries that maintain reasonable figures. You know, high 20s by now, or if you're looking at the expanded definition where people are no longer even bothering to look, you tending towards 40%. That is a disaster, especially for a country with such a large young population. So the practical case for land and agrarian reform, and here I am talking specifically about farming land, although I do acknowledge that land reform is a much broader issue. It rests beyond the moral side, and I think the moral side is important. We cannot ignore the abuses that happened in the past, the restitutionary issues. But if one looks at the at successful, and I will say successful in inverted commas, examples of land reform elsewhere in the world, they followed an economic rationale. Official planning, the National Development Plan, talks about agriculture creating 1 million jobs, earning foreign currency through maintaining positive balances. But understand something, agriculture contributes only about 4% of our GDP, and South Africa is an urbanizing society, as was pointed out earlier. Agriculture is a contributor, and potentially it can be very helpful. But even in a best case scenario, the contribution that it can make is going to be limited, and I think we need to trim our expectations accordingly. It's not something we can afford to lose for reasons I'll get to later, but it's, you know, it is not going to be a solution. The idea that we are going to solve South Africa's socioeconomic problems by planting, you know, one household, 1 hectare peasant farms, it just pushes against the whole tide of history and global experience. Land reform in South Africa. Here I put down a selection of problems. First of all, I think it's become a highly politicized thing. Ideology is a more prominent driver than pragmatism. Now, earlier it was said that we often lack clarity about goals. You know, there's very little focus on the how, and that is very consistent with an ideological worldview. This focus on percentages, transferring 30% of land. Well, you know, what exactly do you mean? Do you mean 30% of land in the Northern Cape? Do you mean 30% of high-value agricultural land? Transferred to whom? Corruption, the capture of benefits. Professor Ruth Hall, who would probably disagree with me on a great many things, did some excellent research about the way that organized business interests and corrupt officials have been pulling one over on nominal land reform beneficiaries, where people can't even get leases for the land that they are nominally being redistributed to them. Weak bureaucracy. Little factoid that crossed my desk some time ago is that apparently in the Land Claims Commission, there's a major shortage of Afrikaans language skills. You're going to investigate transfers of ownership in the 1920s without speaking Afrikaans. It's ridiculous. Extension services. Well, do we really have anything worthy of the name? Now, we talk about failure, you know, figures like 90% are thrown around, 70%. Well, I think those are contested. Maybe we walk into a bit of a swamp by saying, well, you know, what percentage have failed? I think it's more important to realize that this is just not performing well. Land reform is not producing the type of spin-offs that we saw in say Taiwan. So the current trajectory is accelerated land reform. Let's call that the sort of macro concept. And in practice, what this has meant is that the government decides that it wants to intrude on property rights and give itself more latitude. Okay, but understand that this has been coming for a decade. As Anthea pointed out, you know, previous versions of the of legislation have talked about vesting custodianship of agricultural land. We've catalogued about 30 instances since about 2007, and what we end up with is a highly statist approach, ignoring many of the lessons for South Africa's own of successful land reform efforts abroad. And that's why I say we're not doing South Korea, we're doing more Venezuela. And actually, I think ignoring many lessons of South Africa's own experience. The idea that, you know, this mighty developmental state will, you know, push a process forward where it's shown no capacity to do that. Expropriation without compensation, I think EWC has become a sort of avatar for this, and I think it's a very apt one. This has been enunciated as a political commitment, and what it means essentially is state dominance and, you know, the state taking charge. I say though that while you might be able to assist in acquiring land, you know, let's say your idea is that the state should own it. Well, yes, maybe this makes this easier, but I think the price of that will be very high indeed. Trevor Manuel, for instance, said, as one of President Ramaphosa's investment envoys, said communicating this is a bigger challenge than what we thought. Now, there seems to be a great reluctance on the part of business to criticize government, and I think they sense the ideological drivers behind this. So it's dealt with very gingerly, but a phrase that I've heard in private is the word uninvestable. South Africa will be cutting off its chances. The one model that has been done by Dr. Rudolf Botha and Professor Ilse Botha in 2018, it used figures as they existed there, and as far as I'm aware, they haven't updated this, but it's nonetheless very instructive. Says that based on experiences elsewhere, they've worked out two scenarios. One is an EWC drive producing a 5% or a 10% fall in capital formation. Say in countries where this has been aggressively implemented, they look at Spain, Vietnam, Zimbabwe. The average was actually 14%. So we're looking at fairly modest consequences. And here I hope you can see these graphs. Expropriation without compensation. Now, in the event of things just ticking over quarter by quarter, going from 2018, they sort of assume that it's introduced at that point, and then they look at the next 10 quarters. That blue line shows what happens to nominal GDP. It goes up. The orange line, which shaves about 270 billion, I think, off GDP, is what happens with a 5% drop in capital formation and a 10%. I think you're talking something in the effect of about 500 billion. Expropriation. If you talk about real GDP, in other words, you adjust for inflation. And this, I'm really sorry that the picture here is so fragmented, but it's absolutely catastrophic, particularly in that 10% scenario. We are in that sense, after 10 quarters of this, poorer in real terms in terms of GDP than we would have been if in a zero scenario. Now, also note, as I say, this is based on numbers as they existed in 2018. This was before the dismal performance of 2018 and 2019, and this is also before COVID. This is also before, you know, we're talking about, I think, a conservative figure of a GDP decline of what, 7.2%. The risks here are enormous. If you extrapolate that to wages lost and unemployment. Basically you will have the COVID thing again. At a best case scenario, I think investors will hold off and wait and see what happens, and that means another 3 or 4 years. That would be as I say, a best case scenario. Beyond that, we have these subsidiary consequences, implication for trade, especially in agricultural products. If EWC should disrupt the agricultural production, South Africa's agricultural production, it means a lot of lost exports. Many of our high-value foodstuffs are exported, but also it would force us into a much greater reliance on foreign sources. We have this big trading relationship with Thailand, for instance, for rice. We don't grow much rice in South Africa. Now, if you can imagine that being rolled out to maize or to wheat or to things that we produce here, the balance of payments implications of that, and that's what I say. South Africa cannot afford to lose the agricultural sector. The idea that it's 4%, people say, well, okay, maybe farmers can take one for the team and, it'll be a symbolic thing. Well, there will be very real consequences. Implications for other sectors of the economy. I think if there is a move on land, expect other consequences. Expect, for instance, move on pensions. As the state starts, I think that what is not appreciated about this is that property rights may be framed in an idiom of land reform, but the danger of moving on to pension funds, onto savings and whatever, particularly as the fiscal hole grows, is severe indeed. Implications for credit institutions, non-performing loans, for AGOA eligibility, and I think also, and this is kind of the big variant for institutions. Much has been said about the need for land reform as to promote social harmony, and I agree with that on its own terms. Sensible land reform that empowers people, that creates gives people a stake in the system would be worth its weight in gold. If it is done according to the Venezuelan pattern, where it is driven largely by politics, where the act of taking becomes a goal in itself, don't expect that to be confined narrowly. As the damage starts to build up, a government like that will start to look for other targets. Cycle of populism and constitutional vandalism. Something that concerns me very much. The drive to change section 25 of the Constitution is the first attempt to change the Bill of Rights, and no one less than President Ramaphosa has said that this is not actually required, even if there was some argument for compensation-free takings in certain instances. It could be done within the current framework. This seems to be an entirely politically directed attack on the core of the Constitution. Be very, very wary about allowing that to go ahead without comment. Making land reform work. Okay, I think I'm just about out of time, but my little six-point program, which I actually presented at UFS last year. Commitment. Actually take land reform seriously, and it hasn't been taken seriously for all the noise made about it now. Budgets for land reform have I think peaked at about 1% of budgeted spending. It hasn't been a priority, and it hasn't been well catered for. Second is finances. You have to make finances available if you want to give people a shot at farming. And as the world turns, this means more investment is needed. The days of expecting people to be satisfied with hoeing a few meanies out of poor quality earth, I think, are long over, and that's actually why the image is in the background. Greenhouses, innovation. The Netherlands had what I gather was quite a successful plan a couple of years ago, where they said half the inputs for double the outputs, but a lot of that came with, I think, double the investment. Training. Well, we need that. We need that extension service. We need people who want to make a go of being farmers to be able to get the human capital inputs. Administration. That speaks for itself. and infrastructure. Yes, if you are living far away from a center, you actually need some means to transport. And ownership. I'm a firm believer in title, but I do hear what is said about the difficulties, especially for people who have never experienced that sort of legal system before. Nevertheless, I think that the current model, where the state is either represented by an official or by a traditional leader, and the beneficiary simply gets to nod and say thank you, that's long past gone. I think. Let's move to a situation where people at least have a path to ownership. We talk about empowerment. The question is, do you want to empower the state, or do you want to empower South Africa's people? And with that, let me stop presenting and hand over to Hussein to take some questions.
Thank you so much. Well, these 4 presentations were really great. And I'm going to ask people to put questions to speakers in a very crisp manner, so we can make use of the time to the maximum, given the fact that we are a bit over the time. So if you could maybe say where your question is directed to, I would appreciate it. So the floor is open. And I would ask the speakers to just make notes, and then they can come in at the end. Whilst people are collecting their thoughts, maybe I should just pose a question or two to get the ball started. Professor Philippe Berger started off and spoke about 32% of South Africans living in traditional land, and then the issue of the tenure rights. It seems to me that the whole issue that we saw about the Ingonyama Trust suggests to me that the South African state doesn't seem to have the political will to take on these traditional leaders. Would that be a fair assessment, Philippe? Second, to Ina Gous, Dr. Ina Gous spoke about corruption and bureaucratic failures and organizational structures which do not promote effective public policy. Would the land bank fit into that description, Dr. Gous? Dr. Anthea Jeffrey, I was quite intrigued about the issue of custodianship versus expropriation, and perhaps if you could say something about that. And then finally, to Terence Corrigan, our last speaker, this issue of the Bill of Rights being taken on is incredible. And I'm just wondering why people don't make more of a fuss around it. Are they just not aware of this? And how does the issue of what the state is intending meets with President Cyril Ramaphosa's investment targets and so forth? So I will perhaps ask Philippe, and then Ina, and then Anthea and Terence to comment on that for now.
Thank you, Hussein. Yes, I think it's more than just not the lack of political will. I think there is actually explicit steps to increase the power of the chiefs. We need to remember that the Communal Land Act, 2004, the one that was declared unconstitutional in 2010, when it was a bill, there were changes made to that bill that became later law that basically ensured that the ANC won the election in KZN in the general election of that particular year, and ensured that KZN swung from the IFP to the ANC. So there was so those changes made in favor of the Chiefs basically ensured that the Chiefs worked for an ANC victory there. And I think that is very much the spirit that we see there. It is interesting. There is actually quite a bit of research on that by people like Dan de Cat, who did a study on this and found support for that notion. What I do think will be interesting to see is, you know, how the people on this land will vote in future, and whether they will still comply with their traditional leaders' wish to support the ruling party. I think there's also, you know, there's a significant resistance also coming from traditional leaders. If you, the most vocal would be, you mentioned the Ingonyama Trust, it would be the Zulu King. Now, we very often forget, you know, how the history of the Ingonyama Trust. This is something that was set up before the 94 election to ensure that the IFP took part in that election. As you might recall, you know, those of us who are old enough to remember that the IFP's name was put on a sticker at the bottom of the ballot. And they agreed only to take part in that election very early on, to as an effort to strengthen the power of the Zulu King. The Zulu King also in 2018 even suggested that his kingdom should actually secede from South Africa, which basically comes down to restituting the homeland that from the apartheid era. So I think so that is the big irony, and I think the big failure of transformation that we saw in the new political dispensation 25 years ago. So we took away officially the homelands. We took away the president of Botswana and the president of Transkei and the president of Ciskei. But the second level of control, which was vested in the chiefs, and the so-called paramount chiefs who became kings afterwards, that is still in place 25, 26, 27 years after apartheid. So, and I think so. It's not just a lack of political will. I think it was rooted in where this electoral support is. What I also think is interesting is that the official opposition in most of these provinces in the last election, 2019, swung away from the DA to parties like the EFF and again the IFP, and to a large extent in communities where they felt betrayed by the ANC on traditional land. If you compare the wards where we saw the biggest swing away from the ANC to EFF and IFP. So it is something to watch in future. And lastly, just, you know, South Africa is not quite many of the other African countries, because we have almost 70% or almost 2/3 of the population are urbanized. You know, it's about 66% of the population is urbanized. So what that dynamic will mean in terms of voting patterns in future, and the role of traditional leaders, that is something to be seen. Thanks.
Thank you very much, Dr. Goos.
Yes, indeed, Land Bank could have been, I suppose, at this stage, a good alternative or a good way to facilitate land reform when it comes to financing and support. But as we know, it's failed to a large extent. It has difficulty paying its debt, and I think at the moment it was evident that Treasury is reluctant to bail out Land Bank at the moment. I think they promised some help for it, I think about 3 weeks ago, and then recently said no. So Land Bank is in a real crisis, and yes, it is because of incompetence and corruption and all the problems we have identified in many discussions. What is interesting now is the agricultural industry that says they have an alternative agricultural financing institution to the Land Bank could now be established within a year, and that is another alternative way. Away from parallel to government policies and structures to finance agricultural development. So, for instance, Thierry Jager said he's from the World Farmers Organization that an independently owned and financed bank could be up and running around a year from now if discussions go well. And discussions have started a long time ago already, because they see where this is going. And they don't see real attempts to address the real systemic issues within that bank, which led them to be in this crisis. But because of that, but they don't see it, an alternative is being looked at. And I think we're going to see more and more of that as time goes by, and if these structures and administration doesn't get their ducks in a row.
Thank you so much, Dr. Goos. Can I now turn to Dr. Anthea Jeffrey, specifically in terms of the issue of custodianship versus expropriation? You were referring to Justice Mogoeng's judgment in terms of 2013, ma'am?
Sure, let me explain that case a little bit more. It started really in 2001 when a company called Sebenza bought this unused coal mining right for R1 million. And at that point, the Mineral and Petroleum Development Resources Bill was still being developed, but it hadn't yet come in. It was turned into an act. It came into force in 2004. And then all mining companies or other companies that held what they called old order rights were given a year to convert them to new order rights under the new act. But the fee for application was high. It was 1.5 million rand. The company was busy going into liquidation. So it never succeeded in converting its old order right, which then ceased to exist. And it passed into the custodianship of the Department of Mineral Resources, because the whole thrust of the MPRDA was to vest all mineral resources in the custodianship of the state. And now this unused mining right was also in the custodianship of the state. So as I said, the company, having paid R1 million for it and now having nothing, went to court to claim that their right had been expropriated. And they won in the Pretoria High Court, which took the view that all the competencies of ownership used to be with the company, Sebenza. All those competencies of ownership were now vested in the department, in the state. And it didn't matter whether you called it custodianship or ownership. Effectively, there had been an expropriation, and so compensation should be paid in the amount of 750,000 rand. But on appeal, when the matter went to the Constitutional Court, Chief Justice Mogoeng did something which really is quite unprecedented. He drew this distinction between ownership and custodianship. He indicated that expropriation requires the acquisition of ownership by the state. And he said, as I said, the mere assumption of custodianship is something different, because as custodian, the state is simply trying to accumulate certain resources, which it will pass on to others. And he saw this now as a fundamentally important distinction. And because in his view, there was no expropriation, that meant that under Section 25(2), which says that expropriation requires the payment of just and equitable compensation, there was no question of compensation being paid at all. No expropriation, no need to pay. Sorry, let me just take a glass of water. But the custodianship concept has been something that the ANC has favoured for some period. The first example of it came in 1998, when effectively all the nation's water resources were vested in the custodianship of the state. They used the word trusteeship there, but it was essentially the same idea. So all the farmers who had common law water rights, for example, they had riparian rights to draw water from the streams or rivers that ran through their land. All those rights came to an end. They were allowed to retain them for a certain period, but the idea was that they were all now vested in the state and that they would have to apply for water use licenses. And the same with the mineral resources, where all the mineral resources, and 2/3 of them used to be privately owned, were now vested in the custodianship of the state. And these, of course, are the resources below the ground that haven't yet been severed and brought to the surface. And the state would decide who could be given a mining right and hence the opportunity to exploit those mineral resources. You apply the same thing to land, which was the idea with the Agri-Land Bill in 2014. The idea was that all agricultural land was going to be vested in the custodianship of the Department of Agriculture, Forestries and Fisheries. And the further consequence was not really spelled out, but there was an indication that farmers who no longer owned their land would be able to keep using it, provided they had a license or some sort of permission from the government. And there was, of course, a risk that the process, as it had played out in mining, would play out in agriculture, that initially getting the mining right would be not that difficult, but in time further BEE and other obligations would be added. And fundamentally, the mining right would never be secure because the state could terminate it and it could add additional conditions for applying for a new one. And so the same could happen in agriculture. People could initially keep on farming their farms, but in time the state would add more conditions and they would always have a right that could be terminated by the state. Their tenure would become fundamentally insecure. So it's an idea that the government likes, that the EFF likes. It avoids some of the disruption of throwing the farmers off their land. They stay there, they continue to produce, but they continue to produce in a fundamentally different relationship with the state as its licensees rather than as freehold owners.
Thank you very much. Can I turn to Terence Corrigan, please? Terence, about the issue of, well, one, the Bill of Rights, why there hasn't been so much of a discussion around it, and also just this issue of Cyril Ramaphosa trying to secure more investment and then doing things which would just turn that investment off. Is that just a matter of just where ideology meets, I don't know, political pragmatism?
Okay, on the Bill of Rights, my sense of this is the reason why we haven't seen much of an outcry is that amongst a certain portion of the country's, let's say, academic and activist community, the idea of property rights right from the beginning were not wanted. I remember, once again, I'm dating myself, but I remember the debates at the time. You would have people from the National Land Committee going on TV and saying that, well, to the extent that property needs to be protected, there's a massive body of laws. It shouldn't be a constitutional right. It's sort of a conditional privilege, which, an activist government, which and I think that the ANC is still regarded by a lot of people I call deep thinkers as the sort of natural government of the country, the natural leader. It may have problems, but there's an almost parental sense of that as the natural parental figure of South Africa. So of course, it has it stands out above other formations, and if it needs to do this, it will ultimately come down on the right side of history. That's part of it. I think that for many journalists and many other thinkers, it's a sense of giving Cyril Ramaphosa a victory. A lot of analysis, which I believe is fundamentally flawed, was that he was doing this entirely under duress, and he needed to give the sort of hard left or the Zumarites a symbolic victory. But he was playing a long game, and he knew how this was going to end, and it was so. Yeah, I think that fealty to his personality. As I say, I believe that the interpretation is incorrect, but I think that helps to explain it. I think that there was a lot of very facile and shallow analysis. The idea that, well, this won't really mean anything because it'll be just making explicit what is implicit. Well, we have to wait and see how this turns out. But my sense is that any opportunistic move on the Bill of Rights, irrespective of how trivial it may seem, opens you have crossed a policy and an emotional threshold, and that will come back. That will come back to bite you. And I think that many people who are, shrug their shoulders now will be very, very concerned in a couple of years, especially if the drift towards, the drift to decline carries on. Secondly, on investment, I think that if you put pragmatism alongside ideology, ideology is going to win in 9 out of 10 cases. We have a political class that is largely composed of career politicians. These are often people who have known nothing outside some form of political activism, striving for the use of political power. We don't have people who have many people who have run businesses or worked in the corporate sector, or simply had a life outside of that. Remember, if you were in exile with the ANC, that even determined who you could marry, and I think a lot of that mentality has come back. So although I'm well informed that there are plenty of senior people in the ANC who realize how damaging this will be, the leap beyond the ideological, just it's a bridge too far. To which add opportunities for patronage, opportunities for corruption, simple ignorance of economics. But yeah, no, look, I think that and everything that I have personally encountered around this says this is an investment killer at a very best case scenario in the short term, but probably it's another lost decade. I don't think that is decisive to the president's reasoning. I think maybe at some level there's the belief that you can explain your way out of this, but that reminds me of P.W. Botha. If only people would listen that this is really a communist onslaught, they would be behind what we're doing. Didn't work for P.W. Botha, it's not going to work for Cyril Ramaphosa.
Thank you very much, Terence. I want to address the speakers. There's a question from Jack Armour about public interest. Does anyone want to discuss that issue? The issue of public interest, he has put in the chat function. Okay.
Look, Anthea is saying something, but I think he's muted.
Sorry, I took it off on the wrong place. Yeah, I could try to deal with that in terms of what the Constitution says.
Yeah, please go ahead.
I didn't see the full question. It was simply to ask what about the definition of the public interest? Is that it?
The definition of public interest versus what is really in the public best interest brought into the new bill to complement public purpose. How does the panel think public best interest can be determined? Or is land reform assumed to be pursued through EWC to be in the best public interest?
Yeah, well, that obviously raises questions too about what people really want and what people would regard as in their own interest. And there, of course, all the institutes opinion polling over many years shows that land reform is not much of a priority for people, partly, of course, because we are a rapidly urbanizing society in which many people have very little wish for farmland, though they would like jobs and houses in the cities. And I don't think land reform has really ever resonated with South Africans. If you ask them a completely unstructured question, what are the key unresolved problems since 1994? We did that at the end of 2020. And despite all the hype about land reform and expropriation without compensation, we still found 3% of Black people identifying that as an issue that the government needs to resolve. Whereas people are enormously concerned about unemployment, about corruption, about education, about living conditions in the urban areas and so on. So there's a big disconnect between what the public want is in their interest and what the Constitution says about the public interest, which is that it's basically the nation's interest in land reform and also in more equitable access to natural resources. And this I wanted to talk about because it links back to the custodianship thing. It was one thing for the government to vest all water resources in the trusteeship of the state. It was talking about water running in the rivers and dams and so on, coming down from the sky. It's also perhaps similar in some ways to vest the mineral resources beneath the ground, unsevered, unworked, in the custodianship of the state. But it's a very different thing to start vesting a developed farm or a shopping centre in the custodianship of the state, on the basis that this is in some way also just a natural resource. The land is a natural resource, but it's no longer in its original state. It's in a very highly developed state. And you also have a great deal of additional value that's been added to it by the structures that have been built upon it. So the government, I think, is hoping that it can just make an easy analogy. Land is a natural resource. We can vest land in the custodianship of the state. It'll be land and improvements, as the constitutional amendment bill now says, and that'll be just fine. But it does, of course, add a whole nother constitutional challenge that can be raised. If the Constitution defines the public interest as an interest in land reform and natural resources, then developed land arguably simply doesn't fit within that, and taking it is not so simple.
Thank you very much. I'm just going to do the vote of thanks. I think these were 4 fascinating discussions. I think that there is a major crisis about land, about economic and investment trajectories in terms of this country. This was the first engagement that we had with the South African Institute of Race Relations. And I have to say, I hope it's not the last. Thank you all for sharing your views. We will make the recording available immediately after this. Thank you, Philippe. Thank you, Ina. And of course, a big thank you to Terence and to Anthea for sharing their views on this important issue. And I think that going forward, what always amazes me, how public policy is not informed by real expertise that we do possess in the country. And the 4 people who were presenting are experts in this area. So thank you all, and thanks for sharing. And I hope this is not the last event with the Institute. Thank you all. Bye.
Thank you very much.
Thank you.
Thanks, Susanna. Thank you, everyone.
Thank you. Bye.
Bye.
Thank you. Bye.